Put it to the House. Is there anyone opposed to that court? There is. Order. Order. I'm on my feet. Order. I have received letters from Dr. Russel Norman and the Honourable David Parker seeking to debate under Standing Order 386 the Government's decision to accept the recommendation of the Overseas Investment Office to grant consent to Milk New Zealand Holding Limited, a subsidiary of Shanghai Pension Group Co Limited, to acquire the 16 Crayford Farms. I have also received a letter from the Honourable Trevor Mallard seeking to debate the initiating of a police investigation into the Honourable John Banks' electoral spending and the fact that the Prime Minister refuses to stand him down. I will deal with Mr Mallard's application first. Allegations have been made and referred to the police. Allegations can never constitute a particular case of recent occurrence. Neither can the absence of action on the part of a government. The urgent debate procedure is a means of debating matters that have occurred. It is not a means of debating matters that might or might not have occurred in the future. Therefore, that application is declined. The decision of ministers on the sale of the Crayford Farms is a particular case of recent occurrence involving ministerial responsibility. Given the significance of the decision, I would have been persuaded that the matter warrants the immediate attention of the House. However, I am informed that a judicial review of the minister's decision was lodged on the 26th of April. Given that matter, it is again before the courts, the application is declined. A point of order, the Honourable David Parker.
Can I ask how then the opposition would ever get an urgent debate in respect of this issue, given that there will be no ministerial decision required if the court finds there was no illegality? How can we then apply again?
So to which letter are you referring?
The decision on the Crayford Farms, sir, is a ministerial decision of Mr Williamson and others. Yeah. It has been reviewed, judicially reviewed in the courts, as you say, but would that mean that once that judicial review decision comes out, we can then put another application in, because at the moment we can't have it heard?
Well, the short answer is yes, but the member is also aware that standing orders absolutely precludes any opportunity for this House to debate a matter which is sub judice before the courts, and on that basis it is ruled out. Point of order, the Honourable Trevor Mallard.
Mr Speaker, with all due respect, this House is not forbidden from debating a matter which is before the courts. This matter was looked at very carefully, as you are aware, sir, by the last Standing Orders Committee, and there are some restrictions and some notice, and we do take some deference with matters before the court. But one thing is very clear, sir, this Parliament regards itself as supreme and does have the ability and reserves the right to, and goes to the Governor-General every 3 years to, reserve our right to have free speech. And sometimes we choose not to use it. We do have the right to.
Yeah, and I think the member makes some fair points during that point of order. And obviously, this is something not off the top of my head. I've had good time to consider the applications that are before us and to assess the status of the legal action that is intended and the subject matter therein. And given the comparative similar territory to the letters and the appeal which is lodged, I have determined that in this particular instance the debate is out of order according to standing orders. So we move then to point of order, Dr Russel Norman.
Thank you, Mr Speaker. Under Standing Order 112 and 113, you have the discretion to allow the House to have this debate. It's entirely up to the Speaker to decide whether to proceed. And you have certain guidance. There's guidance provided when you are to use that discretion to allow us to have that debate. For example, you've got to balance freedom of speech against public interest in maintaining confidence in the judiciary. Can you tell the House, because this is a very important matter, what is the basis for you exercising your discretion not to allow us to have the debate?
Yeah. Okay. Yep. Well, look, there is a raft of considerations that come in. This is one aspect of it. And I've already referred quite specifically to the similarity between the letters of debate and the appeal. There are other issues, such as the House has already had an urgent debate on this matter. And so across the spectrum of all of the considerations that come into forming a decision, the member is quite correct. It is the discretion of the Speaker. And on this occasion, given all of those reasons, I have determined that it is out of order for the House to have this debate and therefore will not be affording it. Honourable David Parker.
Mr Speaker, Standing Order 113 is interesting, and I will read it out because it shows that this is intended to have effect in respect of generally criminal matters rather than other matters. And if we are to be prevented in this House and the opposition from questioning the conduct of ministers because the minister's conduct is being challenged in a judicial review proceeding, then that seems to me to be outside the protection of what's intended by these standing orders, because what we're trying to do is to stop criminal cases, which is what 1131 is mainly about, in relation to a criminal case from the moment the law is in relation to cases other than criminal from the time proceedings are initiated by the filing of appropriate documents. What we're trying to do is protect third-party interests, not ministers' interests. And, sir, I would have submitted that it's wrong to use these rulings here to stop us questioning ministers' decisions as opposed to protecting the constitutional rights of people who aren't ministers to have their day in court without being interfered by us.
Speaking to the point of order, the Honourable Anne Tolley.
I think the member is being a little selective, because if he goes on to look at 1B, it talks about matters other than criminal matters. And, Mr Speaker, we are getting very close to questioning the decision that you have made in this House.
I thank members for their participation, and I know that this is an issue of particular interest not only to this House, to the wider community, and that's why I can assure the House that I gave this very real and earnest consideration. But this would not be a debate about the principle of overseas sale, because the judicial review is of the Minister's decision to grant. And in that case, it gives it a specificity which directly links it to any matters of jurisprudence in the Court of Appeal. And so it is that is the principal reason that I have ruled it out on this occasion. And I can earnestly say to members that this isn't a seat of the pants decision. I've given this serious consideration. So we move to Government Order of the Day number 1. Sorry, a point of order. I've addressed this matter. I hope the member is not wanting to traverse material that I've already ruled on. Dr. Russel Norman.
My question to you, Mr Speaker, is you said we had already had an urgent debate on this matter. Could you tell me when that urgent debate happened?
Sorry, we haven't had an urgent debate, but the matter was debated in the House during, I can't recall whether it was a general debate or the House, but it has been debated in the House, and I gave some consideration to that. Point of order, Honourable Trevor.
I'm, going back through my memory, but my memory tells me that Mr Speaker Smith, in ruling earlier, had said that when the decision is made, that would be the appropriate time. I think there was quite a long discussion earlier about whether it was appropriate to have a debate, and he said when the decision had been made, it would be. And I just hope that you did read his decision and his ruling on that matter before you made this one.
We are confined by the fact that we have a decision by ministers of the Crown in a judicial process in the Court of Appeal. That is what actually confines us. Look, I've dealt with this matter, Mr Hague.
Yeah, Mr Speaker, I'm not intending to relitigate the matter.
Right, I'll listen very carefully.
What I'm seeking, Mr Speaker, is an answer to the question as to whether it is your ruling that should the judicial review that is about to become underway, in fact, not alter the decision that's been made by the Minister, that this matter will still fit the requirement of being a government action of recent occurrence in order to allow urgent debate to be triggered.
Similarly, I can't predict the nature of the letter that supplied, the circumstances at the time, but members know that they can put in a request for urgent debate at any time. But there are a specific criteria that actually apply, so it would depend at the time. Right, we move to Government Order of the Day number 1. Oh.
But I think there's an important point which I'm happy if the Minister corrects me on. It is my understanding that this is a matter before the Court of Appeal, and they put it so the not. Sorry,
right,
I apologise.
Let's now move to Government Order of the Day number 1.
Taxation, International Investment and Remedial Matters Bill.